Okay, let's jump right into this. We're looking at a fascinating legal showdown today, one that takes a seemingly mundane, everyday neighborhood dispute and flips it into a high-stakes constitutional debate. Welcome to The Explainer. Today, we're dissecting a case that, on the surface at least, is just about a homeowners association asking for a few extra bucks a month. But underneath all that, it's this bitter legal battle over free speech, corporate survival, and the absolute limits of neighborhood power. So what happens when an HOA acts like a government? You know, this question perfectly frames our entire explainer today. It plunges us straight into the heart of a pretty intense legal hearing between a homeowner and his community board. Think about it. Are HOAs just local nonprofit businesses managing shared lawns and community pools? Or are they really quasi-governmental entities that enforce laws and levy taxes? Depending on how you answer that, the rules for what they can and absolutely cannot do change completely.
Setting the stage, we have Section 1. Welcome to Vista Lakes, the 1985 Foundation. To really understand the battle lines drawn between the petitioner, resident Jeremy Whittaker, and the respondent, the Vista Lakes Community Association, we've got to travel back in time a bit. Drafted over 4 decades ago, the original 1985 Master Declaration of Covenants, Conditions, and Restrictions, what we usually just call the CC&Rs, serves as the ultimate star witness in this case. It's essentially the constitution of the neighborhood, laying out exactly what the association can and cannot do with the money it collects from its residents. And that brings us to the crucial point. This exact single sentence from Article 9, Section 1 of those CC&Rs. The association shall not expend funds directly or indirectly to support, endorse, or contribute to any political candidate or issue. Now that seems pretty straightforward, right? But as you're about to see, the interpretation of those exact words sparked a massive formal legal fight over what they actually mean in practice.
Let's move to Section 2, the $25 question, small fee, massive debate.
Let's look at the actual spark that ignited this legal powder keg during a critical 2024 community election. It all started over $25. This was the assessment, or dues increase, that the HOA board desperately wanted the community to vote yes on. To the board, this $25 was a lifeline. But to pass it, they needed the membership to actually vote in favor of it. And to secure those votes, the board decided they needed to campaign.
To get that campaign rolling, the board authorized a $4,500 budget cap during an August 2024 public meeting. They literally set aside community funds specifically to pay for mailers and signs advocating for that very $25 dues increase. And here's where things get contentious. The board didn't just ask the community for a vote in a neutral, objective way. As the hearing evidence detailed, they actively campaigned for a specific outcome using the association's own resources. We're talking Vote Yes signs placed right in the community common areas, Vote Yes mailers sent straight to residents' mailboxes. The board treasurer even used the official Vista Lakes email distribution list to urge residents to vote yes. It was this aggressive, outcome-directed advocacy that triggered Jeremy Whittaker's lawsuit.
Which brings us to Section 3. Whittaker's case, unauthorized advocacy, protecting the membership. Let's step into the shoes of the petitioner here, Jeremy Whittaker. He views the HOA not just as a standard business, but as a quasi-governmental entity that is heavily overstepping its legal bounds and violating that 1985 rulebook. He argues that there has to be a rock-solid line between conducting standard association business and engaging in political advocacy. He points out that if the board can use member dues to campaign for a yes vote on internal matters, like raising dues or changing rules, just by calling it association business, well then that 1985 restriction against political spending becomes completely meaningless. They could effectively use the community's own money to influence every single vote. This quote from Whittaker powerfully captures his stance. During the hearing, he stated that forcing residents to fund campaigns they might personally disagree with is essentially unchecked taxation. He drew direct parallels to municipal governments, pointing out that, hey, a city cannot use taxpayer money to advocate for a yes vote on a city tax increase. He also highlighted that the HOA had previously spent over $100,000 in unbudgeted legal fees. His argument is that the spending was already out of control and residents absolutely shouldn't be forced to fund the board's preferred agendas.
In the courtroom, Whittaker didn't just bring opinions. He brought a meticulous timeline of documentary evidence. He submitted Exhibit 301, photos of the signs and mailers he received. Exhibit 302 was a written warning he sent the board in November, demanding they remove the signs and cease what he called illegal spending. And Exhibit 303 was that mass email from the treasurer. Whittaker's core argument is pretty simple. The exact moment an issue goes to a membership ballot, it inherently becomes a political issue, and HOA funds cannot be used to pick a side. Okay, let's flip the script. Section 4, the HOA's case, vital survival, a fight against bankruptcy. We have to swing the pendulum over to the respondent, the Val Vista Lakes HOA, represented by attorney Josh Bolin. He paints a drastically different picture of the stakes involved here. To the HOA, this isn't about political overreach at all. It's about avoiding total collapse. Their defense is entirely rooted in corporate survival. Their attorney maps out a multi-year descent into severe financial desperation. Starting back in 2021, the association was seriously struggling. Across 2022 and 2023, they put out multiple proposals for dues increases just to save their operations, and they failed. By 2024, passing this $25 increase was absolutely vital just to keep the lights on, maintain the lakes, and pay the community staff. To the HOA, they weren't playing political games. As Bolin argued, they were facing a very real threat of bankruptcy or receivership. They felt they had to communicate their absolute desperation to the community, because if they didn't, the entire neighborhood would suffer the consequences of financial ruin. And this right here is the legal bedrock of the HOA's defense. Bolin argues fiercely that an HOA is a non-profit corporation, not a localized government. A corporate board of directors has a strict fiduciary duty to advocate for decisions that are in the best interest of the business. Restricting them from communicating with their own members to advocate for the corporation's own survival, he argues that would completely hamstring their basic business operations. So we arrive at Section 5, defining political in HOAs, the semantic showdown. This is the absolute crux of the courtroom breakdown. We have two wildly different views on the role of an HOA, but it all hinges on how the arbitrator is going to define a single word in a 1985 document, the word political. During cross-examination, attorney Josh Bolin literally pulled up the Google definition of the word to read into the record, relating to the government or public affairs of a country. He argued that the founders back in 1985 just didn't want member dues being used to endorse Republicans or Democrats in state or federal elections. They never, ever intended the word political to prevent the HOA from running its own internal corporate votes. So this leaves the arbitrator weighing two completely incompatible philosophies. On one hand, Bolin's view, political only means governmental public elections. On the other hand, Whittaker's view, political means anything submitted to a ballot for a vote where there isn't 100% agreement. Is the HOA a private business managing its affairs, or is it a localized government subject to strict limits on forced taxation? Looking back at the original text from the 1985 filings, we do see the formal legal establishment of a nonprofit corporation. So the arbitrator is left to untangle a really messy knot. Did this entity, by printing signs and sending mailers to sway an internal vote, cross the line from necessary corporate communication into illegal electioneering? But before we wrap up, I have to mention this fantastic logical trap Whittaker set during the hearing. He points out that the board used the official managed email distribution list to blast out a vote yes message. He argues this is an indirect, completely unfair expenditure of community resources. Why? Because if a regular member wanted to advocate no, they don't have access to that list. They are structurally silenced, all while their own dues pay to amplify the board's voice. It's a really compelling point. And that leaves us right here, at the end of our explainer. I'm going to leave you to ponder this complex legal puzzle. If an HOA board genuinely believes the community will go bankrupt without a fee increase, are they allowed to use community funds to fight for that survival? Or does the strict wording of their 1985 Constitution forbid them from using forced dues to push any agenda onto a ballot? Where exactly is the line drawn between vital neighborhood management and unauthorized political advocacy? Thanks for joining me on this explainer. I hope this deep dive gave you a totally new perspective on the power dynamics playing out right in your own backyard.